What's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. So, one of the very first Legal Bites I ever recorded, I think it was number 3 or 4 or 5, and I did a lot of talking for a long time about the lead-based paint disclosure and kind of the importance of the lead-based paint disclosure in the old contract. Now, as you guys know, we got a brand new contract that became effective and mandatory for use beginning January 1st of this year. And one of the really fantastic changes that was made to the new contract is that we updated the lead-based paint disclosure language. I whined and whined and whined because the old contract created, if the lead-based paint disclosure, as you guys all know, if it wasn't signed by all parties and the brokers prior to the creation of the contract, then the contract was void. And that was starting to lead to, I think, an increasing number of problems and confusions and contracts that really weren't valid. They were void for all intents and purposes because of the timing issue and execution. And so that problem was identified, and thankfully it has now changed, and we don't have this problem with void contracts anymore. And so the lead-based paint disclosure section was updated. It doesn't make the lead-based paint disclosure and the delivery of that any less important for a number of reasons. And so just because it's changed in the contract, I would strongly discourage you from not, because of not having a void contract, to not address it with the same level of priority and importance that you addressed it before. So we know that now it's in paragraph 10.10 and it's a lead-based paint disclosure deadline. So it got moved from a pre-contract execution and acknowledgement thing to a post-contract. The parties can negotiate the disclosure deadline. When does the lead-based paint have to be delivered by? Do it early. There's no reason not to. Do it very early in the contract period. It's now in paragraph 10.10. So if the residential property is constructed prior to 1978, or for which a building permit was issued prior to 1978, then you got to have one of these things. And this is federal law that mandates this. This is the Environmental Protection Agency and the legitimate federal concern for the safety hazards and harms that may come from lead-based paint that was prevalent prior to 1978. So on or before that lead-based paint disclosure deadline, the seller and licensees must sign and deliver to the buyer the lead-based paint disclosure. So no longer before contract, but before the deadline now. Okay, and then the buyer, after receiving that, can make a determination. Do they want to waive their assessment, not worry about it? Do they want to assess? Is there a reason that they're not going to be concerned about testing for lead-based paint? But they make a decision then, all right? And then the buyer has a termination deadline. So there's a lead-based paint disclosure deadline and a lead-based paint termination deadline. There's no more resolution to lead-based paint, or there's not more. You never had it, but there is not a resolution deadline. In other words, the parties can't have a hard date to resolve by. I suppose they could through an amend, extend, or some other agreement. The seller could agree to mitigate or do something if it was determined that there was lead-based paint, but there's not a specific resolution deadline, just disclosure and termination, and that's it, okay? And that has to be done obviously before the buyer's termination deadline. So what are some best practices with this? Get it out early. There's no reason whatsoever to hang on to this thing and to deliver lead-based paint disclosures or set those dates late in the contract, or even a week or so post-closing. That's too far out. Why do it? The buyer, what federal law essentially says, is that a buyer can't be bound to purchase a residential piece of property constructed prior to 1978 unless they've received this thing. And so the longer you drag it out, the longer you drag out the variability or concern that your seller might have that the buyer doesn't even have to perform based on that. So get it out early. Okay, and get the form back from the buyer. You want to have that in your transaction file as well, the buyer's acknowledgement on that form. Important to have too. And don't skip it. I mean, the challenge with lead-based paint is that the fines that come with this, they hit the broker with them. And these are 5-figure fines that are mandated. I don't know if it's 12 or 15 or 16. It's somewhere in that $1,000 range, and it's expensive. And so don't miss that. It also probably falls below your standard of care from a license law standpoint, and it's too easy not to do. And we've addressed some of the problems with the voidability of contracts as it relates to that, but it doesn't decrease the importance of paying attention on pre-78 construction to that lead-based paint disclosure and the deadlines. Some dates and deadlines we've got here for CAR and NAR events. Love to see you guys at those always. So check those out on our website. And if you have questions about the lead-based paint disclosure, deadlines, or anything else with the contracts or anything else, feel free to call. Well, not anything else, but use your judgment. Call the legal hotline. It's open and available from 9 to 12 and 1 to 4 Monday through Friday, and always love to talk to you on that as well. Thanks so much for joining me, and we'll see you on the next edition of Legal Bites.